tell you a little a home truth about this industry. You have somebody called a producer. Producers are the people who put the whole show together and they make the whole thing run. And they make a success of the show. We're just the morons who sit here and talk to you. The problem with a producer, though, is they get to know a lot about you. I heard the music in my head. You know that music? When I got an email on Monday outlining this evening's show, because it was from my producer, and on the Sunday, I'd said to my wife, you know what we need to do? Because we haven't done it for about 2 years. We need to update our wills. And on the Monday, I got the email from Natasha to say, let's look at estate duties and all the rest of it. And I just thought, I think she's got too close to me, this one. Michael Stein is a tax expert. He's the author of Estate Duty Principles and Planning. He joins us this evening. We're also joined by Cheryl Howard, who's the Managing Director of Cheryl Howard Associates. Guys, thank you for coming in. These problems come up with wills. And I mean, people firstly tend to be they don't want to go into doing wills because it's not a lacquer area, but I suppose it's like doing an antenuptial contract. The more you do up front, the better it is at the end. Michael, let's start with you. How should we be going about things like wills?
Well, I think once one gets married and has a family, potentially has a family, then that's the time to have a look at your will. Maybe not before that necessarily, unless you have assets. But if you're a young person, I think you need to consult somebody who specializes in wills. A lawyer, preferably, or somebody who does this. Once you get married, the couple should have a will.
Now, you say somebody who is qualified, and this is now something that is a bugbear of yours.
Correct.
Let's just get that out the way up front.
It's the Fiduciary Institute of South Africa, and at the moment we're trying to get out to the public to say use accredited will drafters, executors and trustees when dealing with those issues, so that there's no problems going on later on with regards to running away with assets or security from who's ever winding up. There's a website in connection with the Fiduciary Institute, and members actually belong to that. We've now introduced writing of board exams, where it's literally saying to the industry, if you're working with somebody who's drafting your trust or your will, know that that person has got all the education, the experience that can actually put something together for you, because a will you can't undo after you've died.
Yeah.
So you need to make sure that's done properly.
By the way, there's the email address that you can get details about what Cheryl is speaking about on your screen. So jot that down if you need to check up on who the person is that you're actually consulting. Now, you brought up 3 different things there. Now I'm already confused because you said something about will, executors and trustees. Why are there so many different aspects to this, Michael?
Well, with a will, you need to have an executor, preferably somebody who's qualified to do the job, and somebody who's trusted, and somebody who knows the family ideally. Some people prefer an institution, but I prefer somebody who knows the family, you can go to after death. Even the wife, for example, if she's a survivor, can go to and speak to if she needs funds, and they're not going to say, look, you motivate why you need a new lipstick or something like that. Somebody, almost a friend of the family, your accountant ideally, or your lawyer. I think that sort of person should be approached. The trustees, if you have a will, you need trust. A trust, if you establish a trust. When you have a more substantial estate, then you'd establish a trust. But normally,
what do you mean by a more substantial estate? Can you give us a number here?
Not really a number, but if you have assets that are potentially growing in value, you might use a trust to arrest the growth in value and to provide for your family members in the event of your demise. That allows for an element of continuity, because the assets aren't in your estate, they're in a trust. So that trust continues after your death, and the trustees can provide for your family members on a continuous basis.
There's some scary stories that we've heard, and it's one of the reasons why we're doing this show, because we've had quite a few emails from people who've raised this problem where a spouse dies, and it's mainly the female partner in the relationship coming out of a very and I know the society is changing, but it has been a very patriarchal society. And the husband dies, the wife, who has maybe not worked in her life is suddenly left with all of these responsibilities, and there's really nobody to help out. And
Yes.
in some cases, the estate the assets are frozen and they have no money.
Right. You know what, from a practical point of view, just on that, we know that death and taxes are certain, and to that extent do a will. It makes it a whole lot easier for the family members. For losing somebody in the family is traumatic enough, now to try and have to see whether or not there was a will, or do hide and seek with the assets. It's a mission afterwards. If you don't want your family to know about that secret Swiss bank account, leave a note, leave a letter or instructions within your will, and a sealed envelope to your executor to say, these are where my assets are. From a practical point of view, as you've quite rightly raised, Jeremy, is that often to get the letters of executorship before the executor can actually start winding up that estate, it could take almost 4 to 6 weeks. So you're looking at sort of 2.5 months down the line before monies can actually be paid out, or pensions, or the life policy gets paid out, which means that the surviving spouse is literally left on her own without subsistence money for a couple of months. What I advise clients to do is, and I know it's hell of a difficult in today's environment, but to try in a slush fund, keep 3 months worth of savings. And those savings should literally be your phone and your light and water, your food allowance, and to pay your motor vehicle and your household insurance. The bond and the payment of the car can be done by the executors once they get the letters of authority, but keep a slush fund of 3 months. Because often people happen and say, well, you know, my house was in my husband's name and therefore I'm not going to pay the light and water. The municipality will cut it off. The big one is your motor vehicle. You think, well, it's not in my name yet, I don't need to pay the insurance. If you have it in those 3 months period, you're going to have a problem. So make sure, as one of the planning techniques up to bringing a will, that you have those 3 months worth of slush fund. And I normally advise clients, again, from a South African point of view, it's a South African anomaly. We've got antenuptial contracts where people are married still in community of property. And then a lot of families run their accounts, a joint bank account. Now, a joint bank account, on the death of the first dime, that bank account is frozen. So although the wife might have signing powers, on the husband's death, that bank account gets frozen, and then she's stuck until such time as the letters of executorship are issued. Opening a bank account, and with all due respect to my colleagues in the banking industry, should be up there with those 7 high stresses of death, divorce, and moving house. Try and figurize and open a bank account after and having to deal with all of this. So I say to clients, keep 2 bank accounts. You might want to run everything through one bank account, but keep another one ticking over slowly, that on the death of the first signatory, pensions can get paid out, lump sums can get paid out, and the process is not halted because one spouse doesn't have a bank account.
Okay, there's a very practical thing to do up front. What are the other things that we should be doing? Now, Cheryl raised bank accounts and maybe overseas accounts and that sort of stuff. How do you, what should you be putting together so that it's easily facilitated?
Yeah, I think you should keep your family informed, maybe an adult child or the spouse. If you have insurance policies, where they are, you might have a safe deposit where you keep your documents. They should have signing power to gain access to that deposit. You should list things like your policies, for example, the bank accounts, other information that's essential for the immediate time after death. Although one doesn't want to consider those things at that time, but they're necessities. So I think it's sort of an inventory, a list of instructions would be useful, even to advise them while you're alive, not just to leave it sort of hidden under your pillow, just to give a list before and talk to your family and your children, if they're adults, of what's available, and in particular insurance policies, and your will, where your will is, and who the executor is.
We've got one file at home,
right,
which has everything in it. You know, it starts with the will, and it's got all the lists of the insurance policies and a few bank accounts we do have and all the rest of it. So if one spouse dies,
you've got it all in.
You just pull that file out. Hopefully neither of us dies in a fire and that's burnt. You know what I mean? I mean
well, they might both die simultaneously. So the children, or the executor should be involved.
Well, I want to get on to children in just a moment. Let's concentrate firstly on the remaining spouse, and then get on to children, because there's a whole new issue.
Right.
Any other advice, Michael, to spouses, what they should be doing to make it easier for each other?
Well, I agree that you should have that interim fund to fund the surviving spouse, especially if it's the wife, and the husband normally controls the money.
Yeah.
So that should be done. I agree with that, and an inventory of what's there, the sort of file. I think those are the important things to attend to.
How do you go about making all these changes? Because I mean, in a lot of cases, I know, and this is personal here. In a lot of cases, I, for example, pay the rates and taxes and the water and the electricity, so that's in my name. I know, having dealt with the likes of Eskom, Telkom, Joburg Water and Joburg Municipality, that it's not always a pleasant experience. Let's leave it just at that. Now, you know, going about getting those changed into another name,
that's the executor's problem. So fortunately, the surviving spouse
Okay.
doesn't need to deal with that. What the surviving spouse needs to do is just make sure that before the letters of executorship are issued, that she then continues to make the payment. Eskom don't really care whether the payment comes from Mr. or Mrs., provided it still goes into Mr's bank account.
Okay.
It's then, and that's why you then end up paying good executors fees, because they've got to deal with changing of the insurance, changing of the light and the water accounts, transferring the property from the husband's name to the wife's name, transferring the vehicles from the husband's to the wife's. But none of that can happen until those letters of executorship are issued.
Okay, now I'm putting my will together.
Right.
And I appoint an executor who I think will be a really good person to act on my behalf once I die, presuming that I die before my wife. And he turns out to be pretty useless at doing any of this. Can you change the executor, or is that then fixed in stone?
I think you'd need the master's consent to do that. I'm not sure what the
Correct.
procedure is.
Yeah.
You'd need the master's consent. I suppose you'd have to motivate the request. You can't just do it at whim because you don't like their sort of appearance or something. You'd have to motivate a change.
Okay, right. I appoint my brother-in-law, who's a chartered accountant and is a very practical person and knows the family.
Right.
In the meantime, sorry Neil, I hope this doesn't happen, he goes mad. Okay, what the heck happens then?
You always need to, when you draft your will, you actually need a failing person. So, for instance, from a will drafting point of view, in your situation, let's say, for instance, of the example that you're pointing your brother, normally what I advise clients is appoint the surviving spouse as the executor. That person won't be able, the surviving spouse won't be able to do the legwork because they won't have the necessary qualifications, and then they have to go to a professional person.
Somebody would act as
their then you have a failing witch. But then also by appointing the surviving spouse as a co-executor, that person is party to the decision making as to whether we're going to keep the house or sell the house.
Yeah.
Because starting off, I said to you, taxes and death are certain. On the day or the day before you die, there's a deemed capital gains tax event where you've then got to deem to have sold assets. Now for your executor, they need to decide what assets they're going to sell. And if your family is a party of that process, they can then help and be part of that process of selling which assets.
Right, I'm going to hit the pause button
That's
on you
fine,
now,
and
Cheryl. Okay, because we need to go to a break. Michael Stein and Cheryl Howard, our guests this evening in the studio. It's Mansfield's Money Sense. We're talking about wills and estates. We'll be back in just a moment.